This presentation is based on a talk I gave and a paper I presented at International Conference on Islamic Economics at Maldives, the Islamic University of Maldives, and published by their economic journal, Iconi, in 2022. The title of that paper was Islamic Law and Global Law. I'm going to read a portion of the introduction. One way to gain perspective on the new method of global law being constructed is to examine its development from centuries past. That is, to see the basic elements from which it was derived, elements that may have become difficult to recognize because of their overclose familiarity. Another way to gain perspective is to step outside the Western context and attempt to understand both of its legal traditions, civilian and Anglophone, by contrasting them with what they are not. That is, compare them with other traditions of law in a way that will bring their distinctive qualities clearly into view. In fact, there is probably no better way to apply both these means of understanding, historic past and comparative difference, than by examining the two Western sources of global law, civil and common, against their Islamic counterpart. Taking such an approach does not necessarily have to raise the question of which is superior, which is fairer or more just, or which is more suitable for the global age. Instead, the approach can simply employ their differences in a way to illuminate the Western traditions that are being mobilized to construct a global system. However, comparing these three traditions is not only useful because they are different in fundamental and revealing ways, or that they are different in their conceptions of what law is and the ultimate purpose for which each one exists. Equally important is that the three traditions developed in parallel over centuries in close proximity, but in relative isolation from one another. Furthermore, during that time they existed in mutual opposition because of the differing assumptions on which they were based. Even though each tradition has without doubt been influenced by the other, they have for centuries until the present day remained remarkably distinct and separate in relation to one another. It is not difficult to recognize them as clearly distinct strands of legal development. The three traditions also lend themselves to comparison because each of their separate legal cultures is so antithetical to the others and in obvious ways. Those differences have frequently been the source of intense animosities between them, sometimes leading to conflict, even becoming at times a justification for war. When the judges and scholars of one have looked upon the methods and purposes of the other, the reaction has often been a combination of astonishment and disbelief, or even hostility. There have also been strenuous attempts to prevent encroachment by one on the domain of the other. At times, strong disincentives to study and learn or to exchange knowledge have existed between them as well. Thus, despite their long proximity to one another, they have come to represent elements that are irreconcilably dissimilar and incompatible, and hence useful for purposes of contrast. Thus, one of the best ways to understand the architecture of global law being assembled is to compare it with the Islamic Sharia approach to order and harmony.